Good afternoon. I see participants joining, so I think I'll just wait for a few seconds till we have the participants, and then we'll launch. Okay, so I think we have quite a few people here already. So good afternoon, everybody. It's my absolute pleasure to welcome you all to this India ADR week session organized by the Swiss Arbitration Center. I'll just say a very few short words on the Swiss Arbitration Center and then hand over to the moderator and the panelists. So just for your information, the Swiss Arbitration Center is an independent international arbitral institution that provides high quality arbitration and mediation services worldwide, although it is based in Switzerland, under the Swiss rules of arbitration and mediation. You can find all this information on the website of the Swiss Arbitration Center, easily accessible and completely available for everybody to access. So from there, we can move on to today's theme for today's discussion, which is where could Indian parties choose to arbitrate? And we will be discussing a comparison between Switzerland, India, Singapore, and the UAE. This is, of course, a very topical theme given the rise of both international and institutional arbitration in India today. And as more and more Indian parties turn to arbitration, their choice and the options that they have in choosing their seat become more important. I won't say any more about this topic. I would just like to very quickly present our moderator today, who's with us today, Zarina Pundole. Zarina is the General Counsel of Shapoorji Pallonji EPC Division. She has over 20 years of experience in dispute resolution and negotiates a variety of complex cross-border transactions and infrastructure projects in this position. And with her experience in dispute resolution and as a user of international arbitration, I think Zarina is excellent, well-placed to navigate us through this discussion. So without any further ado, I hand over the virtual microphone to you, Zarina. Thank you so much for accepting our invitation and look forward to this discussion very much.
Thank you, Zilba. Those are very kind words. So this afternoon, we have some very distinguished and very seasoned arbitration experts from Switzerland, UAE, India, and Singapore. And each of us give you a sort of overview of their jurisdiction, how arbitration is dealt with there, and try and bring out some of the unique features that they've got. And then we'll have a small round of questions and see if we can identify what are the differences and what are the pros and cons of each of these jurisdictions. I'm going to introduce them from west to east, starting with Felix. Felix Dasser is the president of the Swiss Arbitration Association and a partner of the Swiss firm Homburger, specializing in litigation and arbitration. He is a professor at the University of Zurich for private law and private international law and lectures and publishes regularly on international dispute resolution. So warm welcome to you, Felix. Our second panelist, Thomas Snider, is from the UAE. Thomas is a partner and the head of arbitration of Tamimi based in the Dubai office. Our third panelist is Sanskriti Sidana. She's a senior associate in the dispute resolution practice at Cyril, Amarchand, Mangaldas. Hi. And our fourth panelist is Swee from Singapore. Swee is a senior counsel and a partner in the commercial and corporate disputes and international arbitration practice of WongPartnership LLP, headquartered in Singapore. Please join me in welcoming each one of them. I'll hand it over to Felix now. Felix, stage is all yours.
I think Felix has frozen, so should we move further east, maybe till the frost in Switzerland thaws a bit?
Sure, we can go on to Thomas, and he can give us a background on UAE. Then we'll come back to Felix.
Great. Well, it looks like we have Felix back, although he's muted.
Felix, we can't hear you.
Okay, hopefully it's better now. I think I need to share the screen again. Okay, second attempt, here we go. Arbitration Switzerland. I start with two statistics from the ICC, that's beyond suspicion that they are not particularly Switzerland friendly, that they're in Paris. But Switzerland is actually one of the most popular seats for ICC arbitrations worldwide. In the last available year, 2020, it was the most popular one, actually. Sometimes there are others that are a bit more popular, but overall, it's very popular. And the same applies to the applicable law, actually. Swiss substantive law is very popular. It is the most popular civil law in ICC arbitration. It's only beaten by English law and the various UK laws. And you see here the Switzerland with the red lines. Now, why is that so? For one thing, I mean, Switzerland has a very long tradition of arbitration, international commercial arbitration in particular, over 100 years or so. So people know what they are doing, and people are known to know what they are doing. And we are used to tailor the proceedings to the needs and expectations of the parties from all over the world since a long time. And the arbitration law in practice is very liberal. There's a guarantee of the right to be heard and of equal treatment, but everything else is basically up to the parties. Arbitrability is very broadly defined. Any financial dispute can be arbitrated, and arbitration agreements are held to be valid if they comport with just one of several possible laws. So we normally don't have the problem that the English have and the French when they have a conflict about which law is applicable on an arbitration agreement, and they come to different conclusions as to the validity of the arbitration agreement. In Switzerland, arbitration agreements are valid, period. And we have the full support by the government and by the judiciary. I will tell you a little bit more in a second. Then contract law in Switzerland is extremely liberal, and we have a code, but you can read it quite easily. It's unlike a German code or a French code, which is sometimes pretty difficult to understand. The Swiss codes are written in plain language, and it's also available in English in official translation by the federal government itself. So it is very accessible, much more so than English case law or French or German statutes. It's also very liberal. It's all about party autonomy. When you sign a contract, that's it. You have to fulfill it in good faith. You cannot escape. So, and on top, when you have any question about Swiss arbitration, Swiss mediation, Swiss law, you find everything on one website, swissarbitration.org. You find also the Swiss Arbitration Center there. Now, about setting aside applications. This is pretty unique, if not really unique in the world. We only have one instance. You'd go directly to the Federal Supreme Court, one chamber that is specializing in arbitration. You don't have a hearing. It's a written procedure on the applicability of certain legal grounds, but you don't discuss the facts. It's just about the law. So it only takes about 6 months, and then that's the end of it. In a complex case, it can be a little bit longer, but it's very, very rarely longer than 1 year. Typically, it's 6 months. And the chance of success of an application to set aside is just 7%. The Swiss judiciary trusts the arbitrators and step in only when it's absolutely necessary. So that's probably uniquely arbitration friendly. And everything goes under the heading of Swiss pragmatism and efficiency. We try to tailor the proceedings to the actual needs of the users, whatever they are, where they come from, It depends on what the parties want. And when the parties want to have 3 English cases and English law, then of course it will be quite different than if they choose Swiss arbitrators or arbitrators from elsewhere. So it's really under the control of the parties. Swiss practitioners have an international outlook. Many of them have also studied in a common law jurisdiction. And we try to mix common law and civil law approaches to procedure. So for example, rather normally very extensive memorials in a civil law style that everybody knows upfront what the case is about. But then we have witness statements and cross-examination, a rather more common law style, but more shorter and more efficient. We also have some document production, but reasonably limited. It's not the US kind. So that is, it's everything about efficiency. And if the parties so want, we are willing to help them find a settlement by, at the outset, providing, or not at the outset, but early on, providing them with our initial assessment of the strengths and weaknesses of their cases. It's totally unprejudicial, informal, but it helps the parties to assess their chances and then either settle or at least streamline the later submissions. And with that, I think I've shown you a little bit about Switzerland, and I pass the floor back to Zarina.
Thank you, Felix. That was quite enlightening. Thomas, if you will.
Great, thank you very much, and good afternoon, everyone. It's a real pleasure to take part in India ADR Week, albeit virtually. My task in the next 5 minutes is to persuade Indian users that the UAE is the best place to seat their arbitrations. The UAE ratified the New York Convention all the way back in 2006. I'll come back to that point in just a couple of minutes. And we have 3 arbitral jurisdictions here in the UAE. And those are a combination of a civil law jurisdiction and 2 common law jurisdictions. The first of these jurisdictions is sort of the UAE as a whole, what we often call onshore UAE, and their arbitrations proceed under the federal arbitration law, which after some delays and to much fanfare came into force in 2018. It is largely based on the UNCITRAL model law. UNCITRAL recognizes it as such. And interestingly, it was one of the first arbitration laws to contain specific provisions that expressly allowed for the use of electronic forms of communication to be used in the arbitral process. And remember, this was in 2018, 2 years before COVID hit. So at least in that respect, it was a little bit ahead of its time. We then have the 2 common law jurisdictions in the UAE. The first is the Dubai International Financial Center. It's an economic free zone here in Dubai, where I'm sitting currently, that has its own set of commercial laws, its own court system, and its own arbitration law, which came into force in 2008 and is also recognized as UNCITRAL model law compliant. The third arbitral jurisdiction in the UAE is down the road in Abu Dhabi. That's the Abu Dhabi Global Market, or ADGM. It too, like the DIFC, is an economic free zone with its own set of commercial laws and its own court. Interestingly, whereas the DIFC court is comprised of a mix of both Emirati and international judges from common law jurisdictions, the ADGM court is, I believe, fully staffed by common law judges from around the world. The ADGM arbitration regulations, and despite the fact that they're called regulations, they function as effectively a national arbitration law. The ADGM arbitration regulations came into force in 2015. There were some amendments made to them in 2020 relating to various aspects. I think 3 of the more noteworthy ones are amendments relating to the use of technology in the arbitral process, a requirement relating to the disclosure of third-party funding arrangements, and interestingly, I think, the inclusion of a summary disposal process, or an expedite or a early dismissal type process. You're starting to see such mechanisms emerge in the arbitral rules of some arbitral institutions, but this is the first example of an early dismissal or summary disposal mechanism that I'm aware of in what is effectively a national arbitration law. The ADGM arbitration law is also recognized as being UNCITRAL model law compliant. We've seen, if you look back over the last, I would say, 4 years, a fairly significant shift, albeit a gradual one, in the courts in the UAE. And I think they are becoming much more arbitration friendly. I think they took the passage of the new law in 2018 as a policy shift towards the UAE being more arbitration friendly. And we are seeing courts setting aside arbitral awards in fewer and fewer cases, and being more active in terms of enforcing foreign arbitral awards. When it comes to the enforcement of foreign arbitral awards in the UAE, there is a sort of an expedited process that was put in place with the passage of Cabinet Resolution number 57 in late 2018 on the heels of the new law. And at least in theory, and I understand most of the time in practice, the foreign arbitral award can be brought directly to the execution judge, who is to make a decision on enforcement in just 3 days. I think in practice it may take 7 to 10 days on average, but it's pretty close. That decision is appealable to the Court of Appeal, but it is really designed to speed up the arbitral process. I think I'll close with one little wrinkle, and I'm going to be very limited in what I say about this, because at the end of the day, this is more of an Indian procedural law matter than it is a UAE matter. But as many of you will know, in early 2021, India designated the UAE as a reciprocating territory under Section 44A of India's Code of Civil Procedure, which, as I understand it, means that UAE court judgments can be executed in India as if they had been passed by a district court in India. And I'm relieved to see Sanskriti nodding. I hope I'm getting this right. However, my understanding is that the UAE has not been designated as a country that has, as a country where the New York Convention applies, despite the fact that it ratified the New York Convention in 2006, as I said at the outset. And so there is a bit of a wrinkle there in terms of enforcing UAE arbitral awards in India, but maybe we can come back to that a little bit later. Let me stop there. Thank you.
Thank you, Thomas. Now I'm going to let Sanskriti take.
Thank you, Zarina, and good afternoon, everyone. I am Sanskriti Sidana, and I'm filling in for Shaneen Parikh, who is unfortunately held up with an ongoing hearing and was not able to join the session today. Any mention of arbitration or litigation in India naturally sort of sparks the concern of judicial delays, which undeniably is an important issue. But for the moment, I would like to park that and just focus on what makes India attractive for parties electing their seat of arbitration. Now, firstly, being a common law country, I think India has the benefit of extensive jurisprudence spanning over a century, which has kept up with the changing realities of the commercial world. Indian courts also frequently rely on judgments of courts from other common law countries, such as the UK, Hong Kong, and Singapore, on several contemporary issues, and they have persuasive value. For instance, Justice Cook's decision in the Shashua case has been affirmed in several decisions of the Supreme Court when plagued with the seat versus venue debate, and thus it has become embedded in India's jurisprudence. Now, secondly, the law governing arbitration in India is based on the UNCITRAL model law and is therefore in line with the international standards in practice. However, recognizing that the law enacted in 1996 was in need for an overhaul, due to a phase of extensive judicial intervention at every stage of an arbitration proceeding, the Parliament amended the law 3 times, in 2015, in 2019, as well as in 2021. Now, the aim was clear. It was to make India a preferred seat of arbitration in this region. To give a few examples, in 2015, parties to foreign seated arbitrations were given the benefit of applying to Indian courts for interim relief before, during, and after the arbitration, unless their agreement provides otherwise. It is noteworthy that in India, interim relief can be obtained very swiftly by parties. By virtue of these 2015 amendments, the applications for interim relief are heard by the High Court having jurisdiction to decide the subject matter of the arbitration. And therefore, most matters are adjudicated by judges with significant commercial experience. When it comes to picking the seat across the India, Delhi and Bombay are frequently chosen as the seat on account of their sophistication and the pro-arbitration approach of the judges in these jurisdictions. But even other cities in India, such as Bangalore, Chennai, and Hyderabad, are climbing up the ladder of preference, owing to the strong presence of PE and IT sectors there. Now, next, to curb the endemic delays in conclusion of arbitral proceedings and related court proceedings, the Act was amended to prescribe a timeline for expeditious conclusion of domestic arbitrations. This strict timeline was not made applicable for international commercial arbitrations because the assumption there is that they will be managed by an arbitral institution and will therefore be run more efficiently and systematically rather than ad hoc arbitrations, which were very common for domestic arbitrations in the country. Now, these provisions have certainly had a positive impact on the pace at which arbitration proceedings are being conducted in India now. India also borrowed from the IBA guidelines on conflict of interest of arbitrators and incorporated them in the schedules of the Act. And crucially, the provisions for challenging arbitral awards were further explained to emphasize the narrow scope of interference of courts on the ground of violation of public policy of India. Now, this was intended to effectively undo the wide scope of review that was adopted in prior judicial pronouncements to set aside arbitral awards. And even the patent illegality challenge was limited only to domestic awards. And it has further been clarified that merely an erroneous application of the law or by reappreciation of evidence, awards cannot be set aside anymore. There are several other amendments that have been made to the 1996 Act, but due to shortage of time, I won't be going into more detail on this right now. But I will be remiss to not mention some recent judicial precedents that have cemented India's pro-arbitration approach, with courts making every effort to preserve party autonomy. For instance, in the PASL and GE case, the Supreme Court settled the position that 2 Indian parties can choose a foreign seat of arbitration, recognizing party autonomy as the brooding and guiding spirit of arbitration. And indeed, our discussion today has been made possible because of the Supreme Court's ruling in this case. Then next, even in the Amazon and Future Retail case, the Supreme Court ruled that in an India-seated arbitration administered by an arbitral institution where the rules provide for emergency arbitration, such an emergency award would be valid and enforceable and would be treated at par with awards made by tribunals under Section 17 of the Act, which provides for interim relief to parties by the arbitral tribunals. This position changes, though, where the emergency arbitration takes place in a foreign-seated arbitration. Such orders or awards are not directly enforceable. The usual practice is to apply to a court for interim relief in the same way that the party has applied to an emergency arbitrator, and courts have, if satisfied on the merits, passed orders similar, if not identical, to the emergency arbitrator's orders. So in a way, maybe approaching the courts directly for interim relief, if your agreement so allows, may be a better remedy for parties under Section 9. Finally, I think India also offers parties the benefit of comparatively lower costs of conducting arbitral proceedings. It is no secret that the ever-increasing costs of international arbitration are becoming a major concern for parties. And in the 2018 QMUL survey, 67% of the respondents viewed cost as the worst characteristic of arbitration. I think India offers an advantage in this regard, and with the development of global standard institutions such as the MCI, I think parties can access world-class institutional services, maybe even in India, at a considerably lower cost. Now, in summary, I would just like to say that over the last few years, India, I think, has made great strides in transforming the global perception of it being an arbitration unfriendly jurisdiction. Yes, there are some bumps on the road, and including the one that was just pointed out by Thomas. But I think India is competing at par with robust arbitration jurisdictions of the world, and efforts are being made in every facet for it to be able to do so. And I think ultimately the onus is also on us as practitioners to change the way arbitration proceedings are conducted in India and further improve the situation. Thank you.
Well said, Sanskriti. Thank you. And last we have Swee from Singapore. Swee.
Thank you, Zarina. Well, let me just pick up on one point which Sanskriti just mentioned, which is the Supreme Court decision in PASL Wind Solutions, which affirms the rule that Indian parties can choose a foreign seat of arbitration. This has made the position clear, and in fact is one of the points which I rely on as I seek to persuade you today that Indian parties should choose Singapore as the seat of arbitration. Number one, the Supreme Court decision confirms that you can choose a foreign seat. What then makes Singapore unique and different? Of course, I go to the point of Singapore's position as a result of its neutrality, independence, and impartiality. So these are very key factors where foreign investors and companies, if they are entering into corporate transactions with Indian parties, would want to look at in deciding the seat of arbitration, because any sort of attempt to have the arbitration seated in India may be seen by the outsider or by the foreigner as giving the Indian party a home advantage. So my colleagues from Switzerland and the UAE would then say, well, we are also neutral, independent, and impartial. So I would then respond to them and say that what then makes Singapore closer to India is not just because geographically we may be closer, but we share the same common law regime as India. So Indian parties will be familiar with the common law regime of Singapore, and also very importantly, language. So in the Singapore courts, as they do in the Indian courts and in the Indian contracts, English is the language of choice, which does mean that if you do move on to, for instance, a setting aside application, if you need interim relief given by the courts in support of the arbitration, language is going to be no barrier. The other thing that I would also mention as a second point, which I say makes Singapore unique, is the strong support of the legislature. The legislature has always moved very fast when it comes to amending legislation to be supportive of international arbitration. During Singapore Convention Week, Minister Shanmugam said, what makes Singapore unique is its ability to consult and to be able to pass legislation in a span of just 1 month. And we can see that in the way and how quickly we move to pass legislation to support third-party funding. When we learned that one of our competitors, Hong Kong, was already in the strong and late phase of third-party funding, we then caught up and passed the legislation ahead of time. What also makes Singapore unique in the sense of the legislation is that much as we are all model law countries like UAE, like Switzerland, like India, Singapore doesn't just simply adopt the model law position. So for instance, under Article 16.3 of the model law, it states that a party can appeal a positive jurisdictional ruling, but is absolutely silent on whether a party can appeal a negative jurisdictional ruling. In the Singapore International Arbitration legislation, after going through a public consultation period, we decided that it was actually pro-arbitration to allow appeals against negative jurisdictional ruling. And the rationale for this is, if the parties have decided to go to arbitration and the tribunal gets it wrong and the tribunal decides, no, I have no jurisdiction. And if that is a wrong decision, it is only pro-arbitration to allow the parties to be able to challenge a negative jurisdictional ruling so that they'll be able to persuade the court to say, that's wrong, the parties want to go to arbitration, tribunal made a mistake, so let's move forward and let me appeal this decision. So I think this does make Singapore quite different from many other modern law jurisdictions, which do not allow an appeal against a negative jurisdictional ruling. And I would also say the other part which makes Singapore as a seat extremely attractive is the default appointing authority. So in a situation where there is no default appointing authority, where the parties might have gone for ad hoc arbitration without an institutional rules, the Singapore legislation designates the president of the SIAC court as the appointing authority. And if we look at the SIAC panel of arbitrators, you find more than 500 arbitrators from over 40 jurisdictions, with more than 30 or 35 of them from India. And the third thing that I want to end with in support of my motion to persuade you to choose Singapore is the strong support that the judiciary has for arbitration. Felix made a very interesting observation when he said that the judiciary is pro-arbitration, and he gave us statistics of 7% of successful setting aside awards. In a recent Court of Appeal decision, Justice Stephen Chong noted that over the past years, perhaps the percentage for setting aside is about 20%. If we do a comparison with Switzerland, one may come to the preliminary view that, oh, Singapore is not pro-arbitration if there's a 20% of setting aside of awards. But I say the 20% of the statistics actually speaks to the contrary and speaks to its support for arbitration. A pro-arbitration judicial system only works if the judiciary is prepared to intervene in the right cases, prepared to intervene when the grounds for setting aside are made out, and prepared to intervene when there's breach of natural justice. We all as arbitration practitioners all know the importance of due process and procedural justice in international arbitration. The fact that the Singapore courts are prepared to roll up their sleeves, look into the arbitration record, and step in at the right moment when there is something wrong with the arbitration procedure, or when any of the grounds are made out, I think is actually something that speaks well of a pro-arbitration approach. Of course, the judiciary is also very prompt at issuing interim relief in aid of arbitration, including issuing subpoenas for witnesses to testify, issuing subpoenas for the production of documents, all very pro-arbitration. I hope to engage further in more questions and answers to persuade you more. Thank you.
Thank you, Swee. That was quite an eye-opener and really well thought out, shall we say, argument in your favor to take arbitrations to Singapore. I'm going to start off with a few questions. I think I'll start off with Felix. Felix, you mentioned very clearly saying that the Swiss contract law it's pro parties. It allows for parties to make their own decisions on various things. But at the end of the day, it is a civil law versus a common law. You don't see that there would be some conflict there or some problem in terms of an Indian party, let's say, understanding where the Swiss law wants to take it? Felix, I think you're still on mute.
Now it should work. Okay. No, I don't see any problem. In the contrary, the advantage of Swiss law is that it is accessible. I mean, common law is not the same all over the place. So there are differences, and to find out the differences, that's my experience, is very tricky. You very often need to have a King's Counsel to elucidate you on the intricacies of case law that nobody has heard of outside of that jurisdiction. In Switzerland, you can read it in English. The case law is clearly spelled out in the Federal Supreme Court decisions, well argued, and there are many books about it. You have a lot of literature explaining the Swiss contract law. Point one. Point two, it is very pro-party autonomy. So you don't really need to know about Swiss law, Swiss contract law, because you can be sure that whatever is in the contract, it will be upheld. There are limits, of course. The limits are abuse of law and cheating, fraud and all of that, which are met, of course, in any jurisdiction, also in English law, obviously. But that's about it. So you don't have to deal with intrusive provisions that you find, for example, in German law, or some abstract concepts that you sometimes find in French law. So all in all, I think Swiss law, that's probably the reason why it is so popular worldwide, not just in arbitrations that have their seat in Switzerland. It's also time and again chosen in arbitrations that have their seat elsewhere.
And Thomas, you also touched upon the fact that in Dubai and the UAE, you have some civil law. So would that also be somewhat in consonance with what Felix told us?
Yeah, no, I think that's right. The UAE civil code is largely based on the Egyptian civil code, which in turn is based on the French civil code. So a lot of these similar themes you'll encounter here in the UAE.
Nice. Sanskriti, I also want to touch upon something that you and Swee have both sort of echoed in terms of jurisdictional challenges and how the courts perceive that. Now, Swee made the point that the Singapore courts will roll up their sleeves where there is a requirement. They will go into either a positive or a negative. So how does the Indian court perceive that?
In terms of jurisdictional challenges, if the arbitral tribunal rejects a plea saying that it does not have jurisdiction, and if it rejects the plea that it does not have jurisdiction, then it may proceed to pass an award, and then the law does not provide for an opportunity to appeal that order immediately. However, parties have the opportunity to challenge that award at the final award stage when they are filing a challenge and the setting aside proceedings. And again, they raise the issue of jurisdiction at that stage. However, if the arbitral tribunal takes the position that it does not have jurisdiction to go ahead with the arbitration, then the aggrieved party has an immediate remedy in the form of an appeal to the court.
Right. So, Ian, is that similar to Singapore?
Well, actually, the position in Singapore is that you can challenge both a positive jurisdictional ruling, which means that when a tribunal says, I have jurisdiction, and you can also challenge a negative jurisdictional ruling, where the tribunal terminates the arbitration and says, I have no jurisdiction over this dispute. So what happens in those instances where the tribunal says that I have no jurisdiction? You can then bring the matter to the Singapore courts, and that application has to be filed within 30 days of that decision, and you'll be able to get a ruling from the High Court. I think in terms of timing is about 6 months. Within the time of you starting the case, you probably will be able to get your hearing and to get a determination from the court. If the court then gives a declaration that the tribunal has jurisdiction, the parties can then go back to arbitration and proceed with the arbitration as is. And this is where I say that it's different and goes beyond what the model law requires. And for me, I see this as being pro-arbitration, because much as you can challenge, the tribunal can also get it wrong when the tribunal says they have no jurisdiction, particularly in investment arbitration methods, where a lot of it, for instance, deals with the consent of the investor, whether there's an investment, whether the investor is a foreign investor.
Zarina, if I may.
Yes,
sorry.
Go ahead, Sanskriti. I wanted to jump on this then.
Yes, I just wanted to clarify one thing. I think in India, negative jurisdictional decisions, yes, of course, you have an immediate opportunity to appeal those. But I think the rationale behind not allowing for an immediate opportunity to appeal for positive jurisdictional rulings is to allow the arbitration proceedings to go on without any hindrance. And if the parties do want to raise that issue of jurisdiction at the challenge stage or at the setting aside stage, they may have the option of doing so at that time.
Thomas, did you want to say something?
Thomas.
Yeah, just very briefly, in the UAE, the federal arbitration law and the DIFC arbitration law do follow the UNCITRAL approach on this. So only positive jurisdictional findings are let's say, appealable. The ADGM arbitration regulations, I think there is an argument to be made that under Article 27, a negative jurisdictional finding could be tested before the courts. It's not stated as clearly as it is in the Singapore International Arbitration Act in relation to negative findings. But it does say that if the arbitral tribunal rules on a jurisdictional objection, the court may determine any question as to the substantive jurisdiction of the tribunal. So that's probably broad enough to capture a negative jurisdictional finding, though as far as I'm aware, this hasn't been tested yet.
Maybe just a comment from the Swiss perspective. One thing that I didn't mention is that the Swiss arbitration law is totally different from the model law. It was developed at the same time, but we consciously did not consider the model law at the time, or the model that was being drafted. And even 3 years ago, when we revised the Swiss arbitration law, and I was a member of the expert group advising the government on this, we did not even look at the model law, because although the model law is decently arbitration friendly, Swiss tradition is much more arbitration friendly than that, so that we have much more pro-arbitration provisions. And for example, with regard to jurisdiction, it's a matter of course since 30 years in Switzerland that you can and you actually have to challenge a jurisdictional decision for or against the jurisdiction by an arbitral tribunal right then and there. You cannot even wait until the final award and then challenge the jurisdiction, because you've waived your right. So if a tribunal decides on its jurisdiction, you have 30 days to challenge that decision, and then it takes a few months, and then that issue is cleared up once and for all.
Okay, so in that sense, it's a pretty tight timeline for the party to follow, but at least that's good to know. Felix, you touched upon the fact that at some point in time in the arbitration, not mediation, but perhaps settlement procedure, settlement could be taken up by the arbitrator itself. Could you elaborate on that?
Yes, I have to do so. It's a very unique position, although I just heard yesterday, I'm here in London, and there was at a panel yesterday evening, and there was a lady Aspin from the Court of Appeals, and she told me that they have something similar now in the courts, where the judges provide some unprejudicial advice on how they see the case, right, at an early stage. And that's exactly what we are doing, but only if both parties or all parties want that or agree, then the arbitral tribunal is often willing to provide some initial assessment, not telling the parties, this claim looks good to us. The second claim, there's a problem, set of limitations. The third claim, you have to rely on witnesses. We have seen witness statements that will be tough for you, and so forth, so that the parties know very well where they are. And that is normally done after the first exchange of memorials with the documents and witness statements. So the tribunal has a pretty clear view about the case, although there might be further developments. There will be a second round of memorials, new allegations of fact, new evidence, and there will be a hearing. So things might change, and the tribunal is very well aware that they might then change their opinion. But on certain points, like, for example, application of a certain provision of the law, they will not change their opinion simply because there are more factual allegations or more witnesses. No, it's a point of whatever, Swiss law, English law, whatever, and they say that that's how we read the law. And that helps the parties. And very often then the parties realize that it's not a 0 or 100, it's somewhere between 30 and 40. Let's settle at 35 and go on with our business. Or if they don't settle, they at least know how to focus on with the next memorials. So we do not normally engage in summary disposition, early disposal or preliminary determination, because we tell the parties where we are, and then the parties can adapt and we don't need any specific motion of summary disposal. That again takes time and money. Thank you.
Zarina, you're on mute.
Sorry. I mean, thank you, Felix. That was pretty insightful. I have a question now for all the panelists. How expansive or restrictive does your particular jurisdiction look at when they interpret arbitration agreements? Let any of you all start there.
I'm happy to jump in on this one because I think this is one area where at times there are some challenges in the UAE, and in particular, I think in terms of the authority of a signatory to bind a party to arbitration. The UAE federal arbitration law does expressly require that a signatory must have specific authority to bind a party to arbitration. And so as a result of that, a party does need to be careful when entering into an arbitration agreement with a UAE entity. The counterparty needs to make sure that the signatory does have the specific authority to bind the party to arbitration. Now, there are some sort of presumptions that will apply in this regard. For example, there is a presumption that the general manager of a UAE limited liability company has the inherent authority to bind the LLC to arbitration. However, that authority can be removed from the general manager in the company's articles of incorporation. So it really behooves a party entering into an LLC with a UAE LLC to request the LLC's articles of incorporation at the time of entering the arbitration agreement to ensure that power of the general manager hasn't been removed. So we do see cases where sort of you go through the entire arbitration, and then at the set-aside stage, the award is set aside on what would strike many of us, especially common law lawyers, as an overly formalistic requirement. That said, we can point to some examples of UAE court cases where the courts have done their best to sort of overcome this issue. For example, relying on theories of estoppel and the like to protect the arbitration agreement. So I think the overall trend is moving in a positive direction, but this still remains a hurdle here in onshore UAE.
If I could just chime in on the Singapore position, as you may probably expect, we adopt a very expansive definition of arbitration agreement. So an arbitration agreement is simply an agreement by the parties to submit to arbitration all certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. And we specifically amended our International Arbitration Act to say that an arbitration agreement, while it must be in writing, it will be considered as being in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally, by conduct, or by other means. So in other words, you could have an arbitration agreement that's sort of concluded by the parties by reason of their conduct, but because it's recorded somewhere in writing, and it could be in an email, it doesn't have to be like an arbitration clause in a contract, the court will still find that it satisfies the requirements of an arbitration agreement.
Sanskriti, would you like to add anything to this?
Yes, sure. So even in India, arbitration agreements are interpreted extremely widely. And notably under Section 8, when the amendment was made last, even parties to an arbitration agreement or someone who is claiming through or under him can be referred to arbitration. Now, this issue of whether a party is claiming through or under a signatory to an arbitration agreement has been an interesting one in India, to say the least. Over the years, with judge-made law, third parties have been made a part of arbitration proceedings on the basis of certain factors that were postulated by the courts, which kept increasing. And now ultimately the Supreme Court has recently referred this issue of what can be construed as a person claiming through or under a party to a arbitration agreement to a larger bench to clarify the situation. But in several instances, non-signatories have been made parties to an arbitration proceeding as well in India.
And from a Swiss perspective, as to the form, an arbitration agreement has to be evidenced by text, but that's in Singapore, an email would suffice. And we also have unilateral arbitration clauses. A unilateral clause in a will or testament, in a trust document, or in articles of association suffice as to the form. As to the substantive validity, there's a two-pronged test. The first test is whether the parties really wanted to waive the constitutional right to access to a court. And that's a strict test because party autonomy means that the parties needed to, really wanted arbitration. So only if the courts are convinced, yes, that they wanted arbitration, that first test is fulfilled. And then comes the second test, what is covered? What is the scope of that arbitration agreement? And there the courts are very generous under Swiss law. In case of doubt, everything is covered. So the idea is to avoid, if ever possible, a split of a jurisdiction unless the parties explicitly agreed otherwise. Thank you.
Thank you. I want to touch upon interim reliefs because that's something that quite a lot of us practitioners want, or other users want to know about. So in terms of interim reliefs, how easy or difficult is it in your jurisdiction, your various jurisdictions, to get something like that? And how do you go around enforcing it?
Perhaps I'll just kick off because Sanskriti mentioned the Amazon case for which my firm was involved in. And in that particular instance, it was an India-seated arbitration, even though it was under the SIC rules. And because it was under the SIC rules had these provisions for emergency relief, where the emergency interim relief can be granted by the tribunal. So that was what happened in that instance, where the parties just simply did not go to the Singapore courts to seek the interim relief. They started the arbitration, they went under the emergency arbitrator, they then went to India, and because it's an India-seated arbitration, they could enforce it there and then, like, without going through the Section 9 route. What about if you are in a situation where there is really great urgency, and it is a situation where you can't have and go under the emergency relief provisions under the institutional rules because you do not want to give the other party notice of the application. So you will see that most emergency arbitrator provisions in the institutional rules would have a provision allowing the other party to file a responsive reply. So there'll be times, even though very tight timelines, set for parties to actually, have a right to respond to the application. So in a situation where you're looking for a freezing injunction and the sort of keeping it secret is critical, and you do not want the opposing party to have any notice of it because they could perhaps simply just move or transfer funds outside of the bank account, you can still apply to the Singapore courts under the International Arbitration Act. So if you're able to show that the tribunal is unable to act effectively and the tribunal is unable to act with a particular power, then you can still persuade the court in that instance that, if even though this is an SIC arbitration, if I go down emergency arbitrator, it'll be too late, the other side will be given notice. So I need to come straight to the Singapore courts to, get such a relief. So that is something, so you sort of have both. So you look at the institutional rules, you look at the Singapore courts, it is seated in Singapore, and then you decide which works better for your situation. In the sense of enforcement, which was the other question, Zarina, you had, we have amended our act such that emergency relief is enforceable before the Singapore courts. So if you need to have it enforced, we have amended the definition of tribunal, I think, to include emergency arbitrator so that it will be enforceable.
And Switzerland is also very arbitration friendly in that respect. Of course, the tribunal can issue interim relief. It can even do so on ex parte basis. Under the Swiss rules, for example, there's a provision that allows in exceptional circumstances to grant interim relief on ex parte basis even. Although that would be rather rare, but it is possible. If the alternative always is to go to the courts, you can always also go to court to ask for interim relief, and you can also have an interim relief decision by the tribunal enforced by the courts. You can also, and we now have a new provision allowing foreign arbitral tribunals to come to Switzerland to enforce a procedural decision, like, for example, also taking evidence in Switzerland on behalf for the benefit of foreign arbitral tribunals. And we also, the courts here will, for example, subpoena witnesses to appear before a Swiss arbitral tribunal if the witness does not appear voluntarily. So everything is basically available that parties would need in terms of interim relief. Thank you.
Yeah, broadly speaking, it's the same position in the UAE. All three arbitration laws that we have here empower arbitral tribunals to issue interim measures and of course, allow for parties to go to the court for this as well. One, I think, sort of interesting development in relation to this is that earlier this year, DIAC, the Dubai International Arbitration Center, issued a new set of procedural rules, and they contain provisions on emergency arbitrations. So it's a relatively new development in this neck of the woods. If I can, just very briefly, that sort of relates to another topic here in the UAE that I was going to mention in my opening comments, but I didn't. We did have a situation last year where Dubai issued a decree that effectively merged the DIFC-LCIA Arbitration Center into DIAC, the Dubai International Arbitration Center. That resulted in some ambiguity. I think or lack of clarity. I think we've sort of moved past that at this stage, and it's clear that any existing DIFC-LCIA cases that were already registered prior to March 2022 will be administered by the LCIA in London, and any new cases filed on the basis of a DIFC-LCIA arbitration agreement will be administered by DIAC. But I think it's important for parties to bear in mind that going forward, they should not be using the DIFC-LCIA in any new arbitration agreements. Apologies for sort of going off course there, but I wanted to get that in.
Thank you. We are almost at the end of our session. So I think we'll quickly wrap up. Thank you very much, panelists, for this insightful session. We've learned quite a bit. I've learned quite a bit, and hopefully we will touch base soon. Dilba?
Thank you so much. Thank you also from my end, from the Swiss Arbitration Center. Thank you to all of you for being here and for participating. We have very insightful discussions and tips on arbitrating in each of your jurisdictions. We won't declare a winner for today. Let's just say that everyone's a winner. And just one more message from the MCIA that I have to convey is that this session has been recorded, and you can find the recording as well as the transcript on the adrweek.in website. I'm sure if you Google this, you'll get it immediately. So if you've missed anything, if there's anything you'd like to hear again, please feel free to listen to the recording. Thank you, everybody, from my end, and hope to see you all soon.
Thank you.
Thank you.